Are you an established small business owner or aspiring entrepreneur? Would you like professional advice to help your business grow and succeed? Well, look no further. The Virgin Islands Small Business Development Center is the territory's #1 resource to move your business forward. Enjoy no-cost advising, low-cost training, and technical assistance from experts in both the public and private sectors. The VISBDC is nationally accredited and sustained by the University of the Virgin Islands and the U.S. Small Business Administration. Visit us at our locations on St. Thomas, St. John, or St. Croix, and follow us on social media at VISBDC. For easy access to all our training and networking events, be sure to join our newsletter and download the VISBDC app. The Virgin Islands Small Business Development Center, here to help your business start, grow, and succeed.
Hi, good afternoon, everyone, and welcome to the VISBDC's hosting of the Patent and Trademark Office series. Today's presentation is entitled Patent and Absence Software, U.S. Patent Practice. Allow me to introduce today's lead presenter, Mr. Edgar Guerra-Erazo. Edgar Guerra-Erazo serves as a primary patent examiner and technical trainer in USPTO's Technology Center 2600. In his work, he examines patent applications drawn to artificial intelligence, including computational linguistics, speech processing, and audio compression. Mr. Erazo has served under several details: TC 2600 Technology Quality Assurance Specialist, GS 14 Technical Trainer, and specially trained GS 15 Electrical Engineer Generalist Primary Patent Examiner to participate in a White House initiative to form a pro se pilot program, ART unit. In addition to examining and patent examiner training duties, Mr. Erazo contributes as special advisor to USPTO's Eastern Regional Outreach Office, Spanish Language, Intellectual Property programs, supporting and presenting webinars in English and Spanish for the USPTO's Eastern Regional Outreach Office. Mr. Erazo is also working as International Relations and International Patent Program Specialist detailee for USPTO's Office of International Patent Corporation and the International Work Sharing Patent Programs Division with IP5 and several international patent offices involving patent cooperation treaty, patent prosecution highway, accelerated patent grant, and collaborative speech programs, to name a few. Mr. Erazo is a recipient of U.S. Department of Commerce Bronze Medal Award in fiscal year 2014, Exceptional Career Award in fiscal year 2019, and selected as American Intellectual Property Law Association 2022 Outstanding USPTO Patent Examiner. He has both a Bachelor and Master of Science degrees in Electrical Engineering from George Mason University and a Master of Business Administration degree from the Virginia Polytechnic Institute and State University. Here's a friendly reminder to put your questions in the chat, and they will be addressed by the presenting team either directly in the chat or later during the question and answer segment. Without further ado, presenter Erazo, the floor is yours.
Thank you so much for the warm introduction. It's really a pleasure and an honor to be able to be with you guys today. Once again, we're on behalf of the Eastern Regional Outreach Office and my director and the team, the director Elizabeth O'Herty. It's the great pleasure to be able to share some of the resources that USPTO offers for our audience. And in this case, we're going to be discussing a little bit of patenting apps and software. And so I invite you to, let's go ahead and start this journey. And once again, if you have any question, any concern, let's please put it in the chat, and then we should be able to address it at the end of the presentation. All right. So once again, protecting your intellectual property. In this case, our topic for discussion, patenting apps in software. Just a disclaimer before we start. Some of the references, or all of the references essentially, to particular products, patents, trademarks, service marks, services, companies, and or organizations in this presentation are for illustrative and educational purposes only, and do not constitute or imply endorsement of by the U.S. government, the U.S. Department of Commerce, and the U.S. Patent and Trademark Office, or any other federal agency. So some of the discussion points for today will be a brief introduction of intellectual property rights, or IP, as a business strategy. What is intellectual property essentially when it comes to the different intellectual property rights, patents, trademarks, copyrights, and trade secrets. Also, we will be discussing in filing a U.S. patent application and the process of examination, as well as some of the best practices for filing a U.S. patent application for apps and software. And lastly, we will also be sharing some of the USPTO resources that are available for the audience. All right, so first of all, here we have an image of our headquarters, or the U.S. Patent and Trademark Office, essentially. And to the left, we have an image of something that is quite interesting, and perhaps many people may or may not know it, but this is an example of the incandescent light model of Thomas Alva Edison. So a copy of this model rests on our current director's office. So, but for USPTO, for the U.S. Patent and Trademark Office, which is America's foremost innovation agent, dedicated to fostering innovation and driving economic growth while maintaining a reliable, predictable, and a high-quality IP system. So, how USPTO accomplishes this? This is essentially by issuing patents, which grant the holders exclusive rights to their inventions, and by registering trademarks and service marks for products and services. Just to give you a brief introduction of USPTO, some of the stats that are quite interesting to highlight. There's above 13,000 employees, and these are numbers from fiscal year 2023. Close to above 8,000 patent examiners, above 700 trademarks examining attorneys, 225 administrative patent judges, and also 28 administrative trademark judges. So far for fiscal year 2023, you can see that we have had applications filed above essentially 650,000 applications, from which 340 or about 340,000 have been issued as patents. In the case of trademarks, we see that close to above 700,000 trademark applications, out of which a little bit over 400,000 certificates of registrations have been made. So as you can see, there's a huge demand for innovation, and that can be reflected in the numbers that we see in the patent and trademark filings. But when it comes to intellectual property rights, it is important to recognize that IP or intellectual property should be seen as an IP strategy. And this IP strategy should also be interpreted or observed as a business strategy. So IP as a business strategy, in other words. So why we mention this? So intellectual property essentially is attractive to investors and buyers. And by being attractive to investors and buyers, it can also help enforce your rights, your intellectual property rights, by deterring infringement lawsuits, as well as contributing to increase the leveraging power when it comes to joining with other companies, with buying other companies or businesses in the form of mergers and acquisitions or M&As. Also, if we look at intellectual property strategy as a business strategy, we can see that intellectual property rights offer or contribute, essentially add value or provide added value to a company's asset. And one more important point is that IP strategy as a business strategy should be considered as a global approach, as a global strategy. And we'll try to, I'll go over these because there's a little bit of confusion when we talk about a global IP strategy versus global intellectual property rights. So there's no such thing as global patents or global trademarks because intellectual property rights are territorial. In discussing the intellectual property rights, it's really imperative to see why invention matters, what this means to you, what essentially is the meaning. And when it comes to patents, patents provide and promote innovation and help, by the same token, safeguard our inventions, right? Your inventions, essentially. Help companies grow, provide opportunities for growth and investment, as well as offer benefit to the community by making new goods and services readily available. In addition to these points, patents also provide personal growth, development, and also the opportunity for advancement. With a new patent or a patent being issued, it could be a new technology that is born, or it could be that a new company is born. So it's really interesting to see what is the impact when a patent is issued, when a trademark is registered. So what is intellectual property? In the same approach that we see a real property, a physical property, in which when you are about to buy a property, or when you're about to see what are the boundaries of a physical property, you'll see that boundaries of a property will have a specific limits, a specific measurements that will delineate what is your property and what the differences from the property of your neighbor. When it comes to intellectual property is also a sort of property in the sense that it's an intangible asset, it's an intangible property to a certain extent. Why? Why we mentioned that it's an intangible asset? Intangible asset essentially because you cannot touch it. However, it offers and it presents legal boundaries, legal limits around your invention, around your patent, around your intellectual property rights. In this case, if we're talking about patents, we're talking about the claims, we're talking about the scope of the claims, how is essentially presented the invention, the embodiments that could be described in the specification of the application, but most specifically the claims. The claims are these legal boundaries, these legal needs and bounds of the invention. What are the types of intellectual property? We have patents, trademarks, copyrights, trade secrets, and I'd like to emphasize that patents are new and inventive ideas. Trademarks are used to identify the origin of goods or services, and I will describe in a few minutes what is the definition of each of the different intellectual property rights. When it comes to copyrights, these are creative expressions stored in a tangible form. For example, the lyrics of a song, the manuscript of a textbook or a book, and also trade secrets. Trade secrets is essentially any information that is valuable as long as it's kept confidential. So it's not revealed. It's kept and maintained in secret. So one example is the formula of Coca-Cola. Now, when it comes to an app example, we try to offer a little bit of explanation in terms of what an IP portfolio could be identified as. And essentially, in an IP portfolio, which will definitely have intellectual property rights. And in this case, we can mention patents, trademarks, copyrights, trade secrets. And when it comes to hence examples of patents, this could be utility patents. This could be design patents, right? If we're talking about of an app example. For the case of a utility patent, if an app is novel and non-obvious way of doing something new, causing a change in the real world, or improvements upon. When it comes to a design patent, this can be used to protect the appearance of an app's icon, for example, and various other elements of the app's graphical user interface or a GUI. How a trademark can be seen in an IP portfolio of an app's name, appearance of its icon, essentially, and appearance of the user interface, as we mentioned. So sometimes there's a little bit of overlap in what can be protected, and it really depends on your IP strategy. USPTO cannot offer legal advice, but we do offer IP education, just trying to inform the audience where and how the different intellectual property rights can be seen, or how can you help. We essentially provide information how you could understand or gain knowledge about patents, trademarks, copyrights. For the case of an app example, the code of the app, right? The algorithm of the app in this case, as well as pictorial and graphic works that are incorporated into the app. And trade secret, so we have that in blank because as long as that is maintained in confidence, definitely will still be valuable. All right, so in getting started, it's important to plan early, even before the development of the development process. Create an IP strategy as we explained. In this case, a multi-layer. Obtain help. Research prior art and carefully document and disclose. Prior art essentially are references or documents that could, to a certain extent, describe the invention, describe the techniques that are used in your invention. And when we're talking about creating an IP strategy, in this case, a multi-layer, you need to consider what type of intellectual property should be your first step in the door, right? Whether that is through a patent, through a trademark, or a copyright or trade secret. All right, so now let's talk about patents. What is a patent? So a patent is essentially the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. It has a limited term. This is really, really important. It's territorial, which means a US patent, it provides protection only in the United States. There's no such thing as a worldwide patent. So please, there's no such thing as a global patent. Of course, there are many international patent programs in which an application could be examined in one nation. And if it happens that there is any work sharing program or any collaborative program between these particular nations, that there could be some benefit in terms of being or of examining the application in the other nation. But I think for now it's pretty safe to understand that there's no worldwide patents, there's no global patents, all right? Because intellectual property rights, any and all, are territorial. Types of patents. So we mentioned briefly utility patents and design patents, but we also have plant patents, right? So utility and plant patents, they have essentially a lifetime of 20 years, whereas design patents have a lifetime of 15 years. How does a patent look like, right? How does a patent look like? Here we have an example of the anatomy of a patent. Essentially, on the first page of a patent, where you should be able to observe the date of the patent, in this case, the issue date, the invention title. In this case, we have a network folder synchronization, the name of the inventor, right below the title of the invention. Something that is really, really, really important is the filing date. Filing date will determine we call it the effective filing date, or the date by which the patent will enforce its lifetime. It's right? So 20 years from that date. And it really depends. It could be that there's a domestic priority to a provisional patent application, or there could be a foreign priority. So, but it's safe to think that when you're referring to the filing date, always check that date. Some of the essentially the elements of a patent, we have the abstract offering a short summary of the invention, the written description in which the inventor has a duty to disclose how does it work, how the invention works essentially, how is it made or used. And in that description, you also have to provide additionally drawings or figures. How does the invention look like? And thirdly, we have the claims. And the claims are the most important part of a patent application, of a patent, because these are the claims definitely define the legal boundaries of the invention, similar to a deed of a property, as we were discussing minutes ago. All right, so let's see. What are the hurdles to patenting? So, what could be the barriers to patent an invention? And we have that your invention has to fulfill 3 requirements, and one of them is to be novel, to be non-obvious, and it has to have utility. What's the meaning of these 3 requirements? And these 3 requirements, my apologies that there's some overlapping here, but it's referring to the statutes, to the Title 35 of the United States Code, and it says that 101, 102, 103, and this defines clearly and delineates what's being defined as novel, what is being defined as non-obvious, and what is defined as utility. That it has utility means that it does it function as it's intended. That is novel means that the invention, is it new or was not described in the prior art or known? And non-obvious, it means that the differences between your invention and the prior art would not have been obvious to one in that field. So here we have a nice example. We have the example of a trimmer, right? And in this case, your invention can be identified there in the figure that is on top of the other 3 trimmers. So there's a magazine describing 3 trimmers, and that's been identified as prior art. But how can we see whether those are obvious or are non-obvious or are obvious with respect to the invention? Let me just give you a brief example. Let's say that your trimmer presents a mechanical engine or a mechanical motor, right? And an electrical motor. But the prior art discloses a trimmer that presents a mechanical engine, a mechanical motor. How obvious is that to replace a mechanical motor for an electrical motor, right? You just get a little bit of water. It's much more complex than that, but at the very least, this high-level observation let us know that something is replaced, right? Could that pass the test of non-obviousness, or could that pass the test of novelty, right? So I'll leave you that up to you to think a little bit more about that. So what is prior art? Prior art essentially is or includes patents, printed publications, or other disclosures in the field of your invention that have been published before your effective filing date. So it really depends. So you have in the US, we are first to file. We used to be first to invent, but now it's first to file. So, and there's a grace period of 1 year before the effective filing date. Presenting your idea. Don't be afraid to champion your idea. Diagrams are helpful, essentially, and it's important to recognize that the best or the secret sauce, let's put it that way, of your invention, it's important to maintain confidentiality prior to filing your patent application. That's why there are many ways in terms of provisional patent applications, non-provisional, and different other strategies that you might take. Consult with counsel about safe ways to disclose your invention before filing a patent application. Please search for help. All right. Now, applying for a patent. So here we observe this is an interesting figure that we have. A new idea starts here, and there's a red block. All the way at the end, we see patent in this green block, right? But in between, you have the ability, you have to have in order to obtain or to be issued a patent, you need to present either a provisional application to start with, or a non-provisional application. Of course, a provisional application, which is an optional with approach, will allow you to, with a small number of requirements, to being able to secure a effective filing date. And that's one of the strategies that we try to emphasize. So, for example, if you have a provisional patent application versus a non-provisional patent application, of course, this is only for utility patents. It's really important to highlight that. For provisional patent applications, these are not examined, nor are they published. They have a 1-year time limit, only for utility patents, as we mentioned, and it has a low-cost way of providing or establishing an early effective filing date, or priority date is how we recognize it, in a non-provisional patent application with few formalities. So it's a precursor of the non-provisional. It's a placeholder. It offers you the ability to obtain an early effective filing date. And of course, with this as a smaller set of requirements, something that is really important is that provisional applications, patent applications, are not examined. And also, they're not published. That's really important. When it comes to non-provisional, these receive examination. They have to fulfill all the requirements that are established by the law. And also, these are published 18 months from the earliest filing date, unless there's a non-publication at filing. And these can become patents. Something that is not mentioned here is that when you file either a provisional or a non-provisional patent application, you can have the ability to put on your product patent pending. And sometimes that offers a lot of value when you're testing the market, you're just trying to see whether your product will be able to fulfill the needs of the audience, or the needs of the goods and services that you're just trying to offer. Here are some of the requirements of a non-provisional patent application: filing requirements, as we mentioned, specification, including a description and a claim or claims, drawings when necessary for an understanding of the invention. Of course, the inventor information, including legal name, residence, and mailing address of each inventor, an oath or declaration, or an application data sheet. Of course, the prescribed filing, search, and examination fees are also part of the application. So what do I need to disclose? So a patent, it's interesting to observe that it's a quid pro quo. That means that in exchange for the right to exclude others from making, using, importing, or selling your invention for a limited time period, you have the obligation under the law that you must fully disclose your invention so the public can benefit from it and expand on it, essentially. And this is covered in the Title 35 of the United States Code, Section 112. What do I need to disclose? And this is a part of the 112, Section 112B. So are the claims clear enough that the public is able to be informed of the boundaries of your invention? And also it can be that it can be determined whether the claimed invention meets all the criteria for patentability. All right, so now let's talk about prosecution of your application. So in this figure, we see sort of a route or some sort of like a traffic simulation of what's going on when a patent application arrives on examination avenue, figuratively. So as an application is filed, it receives, first of all, a pre-examination assessment, right? Once that pre-examination assessment is done, it immediately gets routed to the specific examiner under the corresponding technology center where the technology has been classified for the application to be examined. At that point, an examiner will be able to examine your application. And then the applicant will have the opportunity to interact with the examiner. It could be the situation that the examiner provides rejections and or objections. And this is the very same moment that the applicant should be actively be working with the examiner, whether it is answering arguments, providing information that is needed, and also making changes, whether that is the case, or whether the argument of the examiner is not convincing. Try to explain your position. Try to explain why you think your invention is novel, is non-obvious, or it has utility. So it's really important to be in communication with the examiner. Of course, you can make changes, you can make amendments, but to the original, in this case, to the original subject matter of the application, you cannot add new things because that's not permitted by the law. Of course, it could be the situation that if the examiner and the applicant are not in an agreement, it could be an appeal. You could also file for an appeal, or it could be the situation that could end up in an abandonment, or it could be that your application would eventually be in the allowance boulevard, or it could be issued as a patent. So what is the role of the USPTO examiner, right? So for examiners, for patent examiners, they're professionals. They are scientists and engineers, and also legal professionals in some cases that will be reading and understanding your application. They will be searching for prior art. And they will also be evaluating the specification and the claims. Of course, everything with respect to the law, with respect to the technology, with respect to the field of endeavor, in this case, with respect to the technology that the application is related to, and also will be responding in the form of office actions in which they will be presenting their findings, the facts that are going to be explained with respect to the position of the examiner, and not only from the technical side, but also from the legal side. And also, it's highly encouraging that applicants hold interviews with examiners, as you may want, either at the beginning of prosecution, throughout prosecution. It's really important to be actively in contact with the examiner. What is the role of the applicant? The role of the applicant essentially is to file a complete application. Please make sure that all those elements are presented when you file your application, your patent application. Requirements when it comes to the complying what you need to comply in, essentially, right? So complete set of claims, your specification, your drawings, an abstract, a summary of the invention, following the established format that the office is requiring, and also be able to be truthful from the very beginning. you have the duty to disclose anything and everything that you have in your application. And it's better to disclose because it's your duty. That's law. Disclose all known prior art. And that's what I was just trying to highlight. And in response to examiner office actions, please explain your position. Make good faith changes to the application. That's really, really important. Now, is your idea eligible for protection? And this is under the Title 35 of the USC Code, Section 101. It has to be under one of the statutory categories, whether that is a process, a machine, a manufacturer, composition of matter, and improvements of the just mentioned. What is patentable, right? So we mentioned the requirements: novelty, non-obviousness, utility, right? So it could be situations where you may have products and processes, physical things, manufacturers, composition of matter, processes, means to an end, means of doing something new way of doing something old. What is not patentable? You cannot patent an idea. Essentially, these must be able to be developed into a new, non-obvious, and useful machine, manufactured, process, and or composition of matter that can actually accomplish the task. You cannot patent natural phenomena. You cannot patent abstract ideas. When it comes to software and computer architecture, we have here some of those examples: computer error controls, reliability and control systems, AI and simulation modeling, database and file management, document processing, and graphical user interfaces, computer architectures, input, output, and I/O or I/O, inter-process, communication, software development, memory access and control, just to give you a few of those examples of the technologies. So here's we have an example of a software claim. I'm just going to mention briefly, this is a method for synchronizing a shared folder over a network. It has several steps, describing receiving, describing associating the folder, describing the connection between a client and a server, how the file is provided according to a client system, and so on. Here's an example of a software design patent application. So design patents will always start with the letter D after US. And that's the way how you could recognize you have a software, a design patent application. There are training materials with respect to Title 35 of the United States Code, Section 101, describing subject matter eligibility. And this offers guidance explaining how the office personnel, including patent examiners, should evaluate claims for patent subject matter eligibility under 35 USC 101. Abstract ideas, examples, and so on. So I invite you to visit our resources. Of course, when you access our page, you should be able to find these different examples with respect to subject matter and eligibility. When it comes to best practices, it's important to describe the technical challenges in your field of invention, and also specifically describe the engineering solutions that you are coming up with. And in this case, to address those challenges, right? So these can be seen in the operational flow charts. Claim your invention carefully. And of course, really, really important, articulate how your invention improves, in this case, computer functionality, how your solution is unconventional compared to other solutions in your particular field of invention. You have some of those examples when it comes to flowcharts. All right, so I think we have covered a few topics. Now let me just share some of the USPTO resources. So when you go to our main page, www.uspto.gov, you can have the opportunity to get yourself informed about patents, trademarks, IP policy, learning and resources, and also being able to get to see or to read inspiring stories of invention and innovation. Of course, you also have we also offer some resources for education for inventors, entrepreneurs, startups, kids, and different others. Of course, in a nutshell, you should be able to get information how to demystify the patent system, essentially, and there are toolkits for that. So here's the QR code. If you would like to take a picture of that. If you need help in your corresponding area of residence, so you can, we have several regional offices, the main headquarters located in Alexandria, Virginia, but we also have regional offices in a Midwest region, Texas region, the Rocky Mountain region, Silicon Valley region, as well as a new regional office that will be in the area of southeast of the United States, in Georgia, essentially. So, and also we'll be having a community resource center when it comes to in the Northeast in New Hampshire. So we'll be announcing pretty soon more of that information will be coming. So in the different regional offices as well as headquarters, you have the opportunity to connect with inventors and entrepreneurs organizations in your state. You could also get free patent and trademark legal assistance, being able to have access to USPTO. This is through your main page in your region. So I invite you to go ahead and visit that. Here's where we were mentioning our new Southeast regional office that'll be coming soon. Of course, our East Coast region, our USPTO headquarters, and our office hours are from 8:30 to 5 p.m. Eastern Time, Monday through Friday. And what are the core functions of USPTO headquarters? Have the ability to receive and examine patent and trademark applications, U.S. and international IP policy development, oversight and management of USPTO operational functions, as well as stakeholder engagement and training. So if you are not close to one of our regional offices or our main headquarters, we also have what we call Patent and Trademark Resource Centers, or PTRCs. These are because it's a nationwide network of public, state, and academic libraries that are designated by the USPTO to disseminate patent and trademark information, and also to support the intellectual property needs of the public. These centers are authorized and resourced by USPTO. So any and all information that is presented and that is shared and provided at these centers are coming from USPTO. All right. So if you need to find out where is the nearest PTRC, you can go to uspto.gov/PTRC. If you would like to get information about USPTO latest events, we have an events webpage. You could register for upcoming events. Also being able to plan whether you're interested in a particular topic, IP policy, outreach programs, education programs, and different other venues that we have available for the public. We also have a video library or a YouTube channel where if you missed one of those conferences or workshops, you could definitely do a quick search here and being able to see those videos. Essentially, we have access resources for startups as well. So whether you're interested in protecting your IP rights, you have to have a plan for success. You're interested in finding funding, or whether you need to engage with experts. So we have different resources. USPTO doesn't provide funding, but we work with different other entities for which you can get additional information, how you can get educated about those topics. All right. USPTO also has an Inventors Assistance Center, and IAC essentially provides patent information and services to the public. And IAC is staffed by former supervisor patent examiners and very experienced former primary examiners who will be ready to answer general questions concerning patent examining policy and procedure. Here's we have our Monday through Friday, our hours of operation, business hours. And we also, if you're interested in how to file for a patent application, but you don't have legal representation, you don't have a legal counsel, you're just trying to do to file your patent application on your own, we also have resources for what we call pro se applicants or pro se, and we have a pro se assistance program, which is able to provide outreach education to applicants, also known as pro se applicants, who file patent applications without the assistance of a registered patent attorney or agent. So for more information, uspto.gov/pro se patents. Also, we have free legal assistance programs. These are through our patent program, pro bono program. This is a nationwide program that is able to match financially under-resourced inventors and small businesses with volunteer patent practitioners who will be willing to file and prosecute patent applications. Of course, there are certain requirements, and also we have the law school clinic certification program, which permits law students under the supervision of a participating law school clinic supervisor being able to practice patent and or trademark law for USPTO while providing those services to applicants in a pro bono manner. So as we can see, our patent pro bono attorneys, patent pro bono agents, patent pro bono law firms. It's a nationwide network that assists financially under-resourced independent inventors, as we mentioned. So there are some rules that need to be that you need to comply with, and we definitely please take a look at that resource right there. As we mentioned, our pro bono program organizations are throughout the United States and its territories, and also for the law school clinics as well. Our patent and trademark resource centers, as we mentioned, in our pro se program. My apologies, a couple of slides are repeated there. And also, we previously mentioned our USPTO events, but here's also additional information, our QR code, if you're interested. So please stay connected with the USPTO through either our news and updates, our events that USPTO announces, patent alerts, trademark alerts, copyrights. So we invite you to, you can subscribe to USPTO patent alert information. This is a list of some of the resources that we mentioned. Our helpline, 1-800-PTO-9199, and also some additional resources and links. If you have any questions, please feel free to reach out. Here's the email of my director, Elizabeth Doherty, as well as my email. We're ready and available to receive your phone calls, your emails, and if you have a question, please feel free to reach out after this presentation or in the near future. All right, so I think I have concluded my presentation. I don't know if we have questions from the audience.
All righty, thank you for that. I don't see any questions at the moment. I just see everyone saying thank you for the presentation.
Absolutely, my pleasure. Yes, I know it was kind of a long set of slides, but the material that we provided in here will definitely give you a jump start on your invention, on what you have in mind.
All right, so thank you for that. I think it's safe to say we can proceed to the next slide, and this webinar will be converted into an on-demand format, and we will email the participants a copy of the PowerPoint presentation. However, if you're in the meeting and you don't have your actual name, I see iPhone and a few persons I don't see in terms of registration, please send a message in the chat with your name or your email address so I can make sure that you get the post-survey email. And so with that being said, the VI SBDC has so much more in store for you as VI small businesses. You can visit our website at www.visbdc.org. Download the VI SBDC app on your mobile device from the appropriate app store. Like and follow us on Facebook, Instagram, Twitter, Google Business, and subscribe to the VI SBDC YouTube channel for new uploads of our on-demand webinars. Okay, so I see a few names in the chat. So that's pretty much it in terms of webinars we have coming up. I will give an update at a later time, but you can always go to our training portal and see what's coming up. Don't forget to download the app. So no questions. I want to say it's always a pleasure collaborating with the USPTO on initiatives like this. So thank you guys so much. And for everyone in attendance, thank you for attending today's webinar. And on behalf of the entire VISBDC network, we wish everyone a productive rest of the day. Thank you.
Thank you. Take care.